call Dennis O'Rourke.
Thank you, Mr Chair. I have already commented in the previous session of the committee on some of the SOPs which have been submitted, but I did want to comment specifically in this speech about Phil Goff's SOP regarding deaths in hostile action. Now, and the reasons that I want to comment are that I can see that currently, in the current law, there is coronial jurisdiction for deaths of defence personnel regardless of circumstances, in addition to the court of inquiry process, and that process also has a safeguard in that it is itself subject to an external legal review panel conducted by a QC. Under this bill, that coronial jurisdiction will continue where the death does not happen during hostile action. The Select Committee's changes to section 59A2 and 3 will operate to protect the national interest by preventing an inquiry where the coroner determines that the death was caused exclusively by the hostilities during hostile action and not otherwise. But the section, and this is the issue, the section also allows coronial inquiry to deaths during hostile action as well, if the Attorney-General directs that that should happen. Now, Phil Goff's SOP simply reverses that and says that instead the section would always allow such an inquiry unless the Attorney-General acts to prevent it. So it's really just as simple as that. Now, on the face of it, that doesn't seem like a big deal, but I actually think it is quite important, and some other speakers have mentioned the reasons why. I wanted to point out, however, that whichever of those two options, what's in the bill or Phil Goff's SOP, would be adopted, new subsection 59A4A would set out the manner in which the Attorney-General would consider whether to act or not. And I want to read those out because I think they're quite important. In A, it says, whether the investigation or inquiry is likely to identify the cause and circumstances of the death. And B, whether the investigation or inquiry could reveal information that may prejudice the security or defence of New Zealand. And C, whether the investigation or inquiry is likely to examine military tactics. And D, whether a court of inquiry has been or will be assembled under section 200A of the Armed Forces Discipline Act 1971 for the purposes of collecting and recording evidence about the relevant death. So there you can see in a nutshell what the primary considerations are. And so, as others have said, there does need to be a balance here. On the one hand, protecting the rights of families to understand what happened, and the public, of course, as well. On the other hand, there are these specified circumstances which really are extremely important for New Zealand's national interest, and they must be balanced as well. So in deciding which way to go, what's in the bill or Mr Goff's SOP, I think there are three reasons why Mr Goff's SOP should be supported, and New Zealand First will vote for it. And I would ask the Minister if he would consider voting for it as well and making that change for perhaps these reasons and maybe some others. I'm sure we all want a good bill. I'm sure this is not a political contest. We just want something that will work, that will achieve the balance I've spoken of, and most particularly will operate so that the public generally, but most particularly the families concerned, will be able to see three things, and that is this. One, that there has been no political interference, no strange happenings behind closed doors that give rise to suspicion. That's one. Number two, that the process itself is properly transparent. Those matters that I've referred to are properly considered in an open way, and that people can get information about that to satisfy themselves of that. And thirdly, that it does place the emphasis in the right place. And I think actually this is the most important reason for me, Mr. Speaker, Mr. Chairman. And I think it's the most important reason because it's a matter of emphasis. And the emphasis should be, I believe, in favour of transparency, showing the public and showing the families concerned that there has been proper process, that there is nothing to hide, and that the only reason why, if it does apply, that there should be no coronial inquiry is for one of those 4 reasons that I read out regarding the national interest, and for no other reason whatsoever. So I think that those are 3 very powerful reasons which mitigate in favour of the approach taken by Phil Goff and his SOP, and why I believe the government should consider this again. And I would ask the Minister to do so. If he feels that it is not possible for the government to do so, I would ask him to comment why it shouldn't, bearing in mind those 3 reasons that I gave. So if that happens, then I'd be willing to listen to that. But as it is at present, I believe that Phil Goff's SOP should be supported.
David Clendon.